It's on this morning's docket. Case number 109634, City of Dodge City v. Webb.
May it please the court if I could please reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. The issue before the court today, in and of itself, is relatively simple. Can a law enforcement officer statutorily request a warrant if the individual has refused to submit to testing pursuant to the Kansas Implied Consent Law? However, obviously based upon the United States Supreme Court's recent decision in Missouri versus McNeely, the calculus may or may not have become a little bit more complicated as far as the Constitution is concerned. The statutory interpretation really has not changed and is still just as simple as it would have been prior to the Missouri versus McNeely case. I think sometimes in statutory interpretation cases such as this, we lose sight of the forest through the trees. And if we would actually look back to the original purpose of the implied consent law itself, the calculus or the analysis becomes much easier. In this case, we're dealing with the Kansas Implied Consent Law. And like all other implied consent laws, they came about as a result of the United States Supreme Court case of Schmerber versus California. In that case, the United States Supreme Court, well, they say they didn't quite say this now, but they seemingly said that if you have a DUI arrest, that due to the dissipation of alcohol in that individual's blood system and due to the exigent circumstances of that evidence basically being lost, that based upon a lawful arrest, meaning there's probable cause, that a law enforcement officer could go ahead and forcibly draw blood or take a sample without first obtaining a search warrant from a neutral and detached magistrate. That, back in the 60s, did not sit well with the general public and did not sit well with the Kansas legislature and other legislatures. And so the intent and the purpose of the implied consent laws as they came into effect was to prevent that from happening. Nobody wanted an officer forcing somebody to be strapped down to a chair and having their blood drawn from them. So the legislatures used the exception to the warrant requirement, seemingly carved out by, and it was carved out by, in quite all due candor, carved out by the United States Supreme Court in Schmerber, which said if you have a lawful arrest and if there's probable cause and it's a DUI, then you can go ahead and draw blood. They use that in order to lawfully coerce individuals into submitting to breath test or blood test. And what I mean by lawfully coerce is there wasn't a need for a search warrant. Once a person is under arrest, based upon Schmerber, there was exigent circumstances, so they could go ahead and draw their blood anyway. Legislature didn't want that. Legislature also didn't want anybody being subjected to a forcible blood draw, period. So when they passed the implied consent laws, they did it not to give an individual a right of refusal, but they basically gave them a statutory option of refusal. And what the courts have interpreted ever since the implied consent laws were passed back in the 60s, consistently, all the way up until today, the Kansas Supreme Court, the Kansas Appellate Courts, the Kansas Attorney General's Office, has consistently and uniformly interpreted it exactly as it was intended, which was to prevent forcible blood draws and to give a licensee or an individual who's under arrest and being processed under the Kansas Implied Consent Law the option to say, no, I don't want to take a blood test, no, I don't want to take a breath test. And when they exercise that statutory option, that statutory right, that ends it.
Isn't it true, though, that all of that case law that you're referencing was interpreting a statute that changed pretty significantly in 2008?
It didn't change significantly in 2008. And that's why I said...
Well, do we have anything that, sort of to your recitation, that courts have uniformly held this way? Do we have any such decisions after 2008?
Well, other than Hoffner, which is up next.
Right. We just have Webb, this case, and Hoffner, which
Webb
comes
and
next,
Hoffner,
right?
And so, but our argument is look what the argument is for the fact that the legislature, just by moving statutory language, it didn't eliminate the fact that they said if an individual refuses, and a law enforcement officer can get a warrant, but only if there's an accident involving serious injury or death, and a traffic infraction occurred, and the officer is being processed.
They did eliminate the key no further testing language, correct?
No, it didn't, in our opinion, eliminate.
Well, where is that in the 2008 version?
Well, it doesn't, because it's still implicitly there, because it says if an individual refuses, and there are these things.
I
then
understand
you can
that
do this.
that's your argument that it's implicitly included in the structure of the act. But my question just narrowly, we can agree that it's not explicitly there anymore. It was there and now it's not there.
With those few words, yes, but the fundamental purpose, I'm hoping, hasn't gone away.
Okay.
Except that if you eliminate those essential clear words, that there will be no testing, and you're left with subsection P, why is P not just a statement that here is a situation where the law deems probable cause, and that's the intent of P, is just to direct everyone that in this situation probable cause exists and go for the warrant. But why does that, saying that, necessarily eliminate the possibility of using other warrant exceptions for a search or a warrant itself in other situations?
Because what that would do would be to completely eliminate the fundamental purpose of the law.
But isn't that what they did when they said there will be no further testing?
No. Well, no, that was, if anything, was redundant. And to be honest, why would the legislature, and this is our argument, why would the legislature create a law that's been interpreted the same way for 50 years?
Except it hasn't been interpreted that way in other states, and there was a growing trend in other states not to interpret it that way.
And that's because
And
they've
maybe
lost.
the legislature was aware of that.
And that's because the legislature has lost sight of what the original purpose of the law was.
And don't they have that right? Don't they have the right to change that purpose somewhere?
Sure, they certainly have that right, but then if they're going to actually do that, you would think they would do it much more explicitly, and they wouldn't still continue to contain the language in the statute that, yes, you can have a medical personnel go ahead and conduct a blood draw if there is an accident with serious injury. That language wouldn't need to be in there at all,
Yes,
because
it
you could
would.
always get a warrant.
If you were, at that point, no longer relying on consent, but on exigent circumstances, as a warrant exception, that language is still necessary from a medical provider standpoint.
Well, from a medical provider standpoint, possibly, but again,
And isn't the legislative history of that it was the medical profession that came and said, give us some protection here?
I think the medical profession, from my understanding of legislative history, wanted some more protections, yes, but I don't think the legislature did that at the cost of saying, oh, we're also going to eliminate an individual's option of refusing. And that's, again, goes back to, hopefully the legislature has not completely lost sight of the purpose of the law. And then 60-some years, 50-some years later, turned around and said, well, we're going to now ignore the fundamental purpose of the law. An individual no longer has an option of refusing. That simply just doesn't make any common sense at all. Why would they do that?
Maybe they wanted to change the purpose of the law.
Then just get rid of the law.
Well, they
mean,
changed the law.
But there wouldn't be any need for the implied consent law then.
Yes,
Because
sir.
you could just get a warrant like you would in any other case, which is actually what I argued before this court in State versus Nisi, which is kind of where we're at now. And that's actually what really does need to happen. You have this huge mechanism called the implied consent law that was premised upon the fact that you didn't need a search warrant to obtain a blood draw if you had a lawful arrest, and that foundation now no longer exists.
No, there's still a very valid purpose in getting people's consent.
But you're not getting their
does-
consent. And that goes back to the Nisi argument. You're not getting their consent. You're coercing them. You're saying, if you don't take this, you're subject to potential criminal sanctions. If you don't do the test, you're going to lose your license longer. Those were all lawful consent beforehand. And this is a statutory argument, so I know we're not getting into that.
Well, no,
those
those
were
are-
all lawful before, but they no longer are.
Those get into the due process considerations that have been weighed in terms of balancing that. So that's kind of a different test and formula.
That would be for the licensing issue, yes, and I understand that. But as far as criminal interpretation, an individual had two rights. Number one, it had to be obviously a valid search under the Fourth Amendment, which was protected by Schmerber. That no longer is. So all the coercion that takes place under the Kansas implied consent law now is extremely problematic for the state, and it's going to have to be addressed. But the court's going to deal with that in State versus Nisi. But then we still have the statutory protection that says that an individual has an option to refuse. And that statutory framework and protection is still there. The legislature has not eliminated that. That still exists. And there hasn't been a single issued opinion by this court or any other court in the state of Kansas that I'm aware of.
Why does just in sort of a conceptual sense, why does the state's ability to get a warrant entirely vitiate the benefit that the legislature would have conferred on an individual who wants to either withdraw or refuse consent? I mean, it seems to me that even if the state is put to put to a higher burden of obtaining a warrant, there still is a benefit, statutory benefit conferred on your client, for example, in refusing. It seems to me your argument is there's no point in allowing a defendant to refuse if the state can just turn around and get a warrant. Am I misunderstanding your argument?
No, but then my argument still stands. Why would you put this huge, costly framework in place of the Kansas implied consent law and have an individual be read all of his implied consent rights and told all of these things, and then said, "Do you want to take a test or not?" And they say no, and they said, "Oh, never mind, we're going to get a warrant anyway." It makes no sense.
Yeah,
And that wasn't
but-
the purpose. The purpose was to prevent that very thing from happening, was to prevent an individual from saying, "No, I don't want to take a test." And the officer said, "Well, we're going to tie you down and take your test anyway." That was the purpose. And you're eliminating, or the legislature is eliminating that fundamental purpose of we don't want forcible blood draws unless it's a really serious situation like an accident where somebody's died or been injured. We don't want that to happen. So no, that is the purpose that would be eliminated. That is the force. That's not the tree. That is the key to this whole case.
But what I'm not understanding is that the purpose is to eliminate the forcible blood draw. So there is a mechanism set up that pushes people to want to consent so that they don't physically fight the blood draw. Isn't that the purpose?
No, because you could just ask somebody that anyway. The legislature is
But there's
legislature's
there's
trying
an
to prohibit it.
incentive, and the
There's an-
incentive is to get them to voluntarily consent. In South Dakota versus Neville, the U.S. Supreme Court said, what we're doing here is giving that driver some hard choices, and that those hard choices will hopefully push them towards agreeing voluntarily to the test.
That wasn't the intent of the Kansas implied consent law, and it hasn't ever been interpreted that way. Not once.
We've cited that several times in many cases.
I understand, but D and all the published Kansas court cases prior to this, including the Attorney General opinions, have always indicated that an individual has the option of refusing, which is intended to prohibit search warrants being issued afterwards. Because of that very thing, they don't want forcible blood draws. If they want to get rid of that, as easy enough to do, they can just get rid of the implied consent law and say the implied consent law only has to do with licensing issues. The criminal searches are all entirely separate. That would be the easiest and simplest way to do it.
Aside from arguing the amorphous broad purpose, point me, if you will, to the specific provisions of the 2008 law that demonstrate that intent, that the legislature intended to prevent forcible blood draws via a warrant. Where is that in the current statute?
Because the language would be superfluous if it didn't have that intent. By saying,
So you're all,
by
I
saying
just want
if
to
it-
clarify.
no,
Your argument is from intent only. You have no specific provision.
yes,
in
the
statute.
provision that says that if an individual is involved in an accident involving serious injury or death, and these other circumstances exist, then you can get a warrant.
So that's D. So,
Yes.
Is that right?
Yes.
So within subsection D, it is specifically limited to a blood draw at the direction of a law enforcement official, right?
Well,
That's what the entirety of subsection D starts out with.
Of
law
course.
enforcement. So distinguish for me, or tell me why the Court of Appeals in Webb was wrong to say, look, subsection D does not apply because a warrant is a direction issued by a judicial officer.
which is it just doesn't make any sense. You're saying a judicial officer is going to go out of his way to go get a warrant and direct this on his own? No, it's all going to start from a law enforcement officer. That's
I
where it
just
starts.
want to narrowly focus in on the actual language of the statute.
It
And
is-
you've told me subsection D is what you're relying
It's
on.
semantics without a difference. But of course, it's going to start with a law enforcement officer asking for a warrant. That makes no sense. How else would it start?
Well, it would start that way. However, subsection D talks about giving direction for a blood draw, right?
Of course, it's going to come from a law enforcement officer. Where else would that come from?
Well, it comes from a warrant. Isn't a warrant a
Who
direction?
gets the warrant? Who applies for the warrant?
Okay.
If a law enforcement officer has a warrant, say a search warrant, let's take it in another context for drugs or whatever, does that officer, is that officer mandated to execute that warrant? If you go to a magistrate, get the magistrate to sign the warrant, and then decide not to do the search, is there any consequences? Is the does the court have any sanctions against a law enforcement officer for not executing?
No, and there's a series of cases on staleness that allows for, if an officer even delays in executing it, sometimes the validity of that warrant will no longer be valid. So no, there is no sanction against a law enforcement officer, except for the law enforcement officer, if he waits too long, that may no longer
Now,
be a valid warrant.
where I'm headed with this is that really a direction from the magistrate, or is that permission from the
And that-
magistrate? Is my question.
It's permission from the magistrate. It's just the opportunity to do it if the law enforcement officer asks for it, and then gets it, and then executes it. But that's why it's a neutral and detached magistrate. They're not directing the officer to do it, they're allowing them to.
Do we have any further questions? Seeing none, thank you, counsel.
Thank you.
May it please the court, I would like to focus on I believe, the legislative intent of the law.
Before you get
Yes.
started, would you address my question? When you get a warrant from a magistrate, is that direction or permission?
I believe it is a direction. I believe that if a person that was subject to an order of the court to provide their bodily fluids or whatever, if they refuse to do that, it'd be my understanding that they could be held in contempt of court. So I think it is an order.
No, I'm not talking about vis-a-vis the person. I'm talking about the warrant vis-a-vis the law enforcement officer. Whether the direction to give me the fluids is at the direction of the law enforcement officer, even though he or she has a warrant in hand, or whether that really is the judge directing the person rather than permitting the LEO.
I
You
believe
understand my question?
Yes, I believe it's probably somewhat of both. I believe the judge is directing the officer to carry out that duty that he has requested to do. At the same time, I believe the officer, under circumstances, can, within discretion, not decide to strap someone down or perhaps order a medical professional, you're going to do this, or whatever. Anecdotally, we have instances where the medical professionals in Dodge City refuse to carry out the search warrant if the subject is too combative. So I don't know what other options you are. At that time, I suppose the officers could take the individual to the sheriff's department, strap him in a chair, and get an EMT to carry that out, but the hospital won't do it.
Would the provider be subject to contempt of court?
I don't believe so. If they had reasonable, if they had reasons that they did not believe it would be safe to try to inject a needle into a combative individual.
And you understand where I'm going. If they're not subject to contempt of court, then how is that a direction from the judge rather than from the LEO?
So I think it's kind of a mixed bag.
Okay, thank you.
It would appear that the legislature has been raising the ante in DUI laws for many, many years, and I don't believe that they meant to stop that in 2008 with this particular statute. There have been more severe penalties. There's been added on to try to deter the driving under the influence. We have, they took out the language, as the court has indicated, that says, that was a directive that no additional testing be applied. I believe that the Webb court got it right in the fact that they said a law enforcement officer does have the right, after refusal, to seek a warrant, and of course it has to be on probable cause, and that law enforcement officer must obviously convince a neutral magistrate that probable cause does exist. There's always been a coercive factor in obtaining these under the implied consent advisories, and there's no indication that the legislature wants that to stop. We have if you didn't have the warrant requirement, the officers run into many occasions in our area where people simply don't have a driver's license. So it's not much of a help if they attempt to coerce them to, or convince them to take a blood or a breath test, if all they're going to do is suspend a license that does not exist. So they're, along with the legislative intent to protect the public through the policies, they must have some other method. And one of those methods would be is to, if upon probable cause, convince a neutral magistrate that we do need a warrant to attempt to obtain the evidence in order that the people who do drive under the influence be punished for it. Like I say, it is not much of a punishment to suspend a license that does not exist. And if we did not have an alternative.
But doesn't the history of the statute speak the opposite? As Mr. Hollins pointed out, it appears that the history of it is that, at least for a long period of time, the legislature very specifically said that if someone doesn't consent, there will be no more testing.
And I believe they saw the error of that by the fact that there were so many people just who did not have license.
And if so, why did they keep any mention of a restriction about warrants, or that could, any language that could possibly even be construed to be a restriction about warrants? Why didn't they just say, go get a warrant, instead of?
I believe they could have. However, I don't believe it's necessary for them to state it that plainly.
What does P mean?
Excuse me?
What does subsection P mean?
I'm sorry.
What does subsection P of the statute mean?
I'd have to be reminded.
It is the provision of, well, I can just read it in full to you. It'd probably be more fair than for me to try to summarize. An officer shall have probable cause to believe that the person operated a vehicle while under the influence of alcohol or drugs or both, if the vehicle was operated by such person in such manner as to have caused the death or serious injury to a person. In such event, such test or tests may be made pursuant to a search warrant issued under the authority of KSA 22-2502, which is the search warrant statute, or without a search under the authority of 22-2501, which is the former search incident to arrest statute that's now been repealed.
I think they were trying to be clear that in those situations that a search warrant could be applied for.
But not
But
trying
did-
to, but
but
not
did
trying to
they-
limit.
Is the intent there to limit it to the serious injury accident?
Well, they also added the language that nothing should limit the ability to admit evidence that is obtained by a search warrant. So I think those may collide a bit, but that language is there. It says,
I
you
think
know,
that
nothing shall.
language was there before, wasn't it? That wasn't added in 2008. I know it exists in 2001, version of the statute, 1988 version. I mean, the part about nothing in this section shall be construed to limit the admissibility of
Correct.
evidence collected per search warrant. I mean, the way this works is, the Fourth Amendment obviously permits law enforcement officers to obtain warrants in certain circumstances on showing a probable cause after review by a neutral and detached magistrate, etc. So then we have a statute that for a long period of time cut back on that, and in essence granted potential defendants in Kansas, individuals, citizens of Kansas, greater rights than they were guaranteed by the U.S. Constitution. You'd agree with me that far, right?
Yes.
Okay, so then in 2008, the legislature takes out part of the language that granted those Kansas citizens additional rights, but leaves in part of the language, and that's where we're stuck. in essence, right?
Yes.
So, but what you're saying today is that P, that language is left behind, or a portion of that language is left behind. I think you can read subsections D and B2 as well to leave part of that protection in place, is limited to that particular. I mean, that's now limited. And in all other circumstances, we revert to what the Fourth Amendment allows.
I certainly don't want to say that that's not problematic, but at the same time, I believe that the Webb court decided it correctly in saying that there still must be probable cause before a warrant can be issued.
Obviously, yeah.
Yeah.
Yeah, that would, I mean, that would have to be in place. It's just whether we read P and D and B2 to mean that those are the only, the accident or serious injury or death are the only circumstances when you can go forward.
Well, that doesn't make a lot of comments. To me, that's not common sense that we are saying that only if the person is badly injured or whatever. All drivers who are under the influence of alcohol present a
Dangers.
a danger to the public.
Right.
So I believe perhaps they were just being.
But is it nonsensical for the legislature to say only when that danger has been realized at this nth degree are we going to permit basically forced blood draws or coerced blood draws?
Well, I think if the whole act is taken into consideration, that the intent of the legislature is clear, that we shouldn't limit or read that too closely and limit it only to those situations.
So the whole act and kind of the trend. Those are your arguments, right?
Yes.
Okay, thank you.
And I guess I'm not, if you have three different provisions that were just described that still retain the old scheme, and we have our construction rule that we don't construe a statute to as if the legislature was being superfluous or enacting meaningless provisions. Tell me why, as a whole, we can say with any level of certainty that the 2008 enactments were intended to make a sizable or a significant shift in the direction of the statute.
Well, they did take out the language that made it clear previously that no additional testing is allowed. And in 2008, I believe they wanted to make it clear that additional testing would be allowed.
See, that's, I understand that argument,
Yeah.
but that's a specific phrase. And I understood you to argue that you have to look at it as a whole and interpret it in peri materia, and that's where I'm not in step with you right now, because other than that language, they left all the other stuff that was there before.
It seems to me that a person who is under arrest for DUI, under suspicion, that the legislature would want to have the evidence to prove that that person is either under the influence or not. And the only way to get that after refusal is through a search warrant.
I understand, but one of our construction rules is that no matter what we may think the legislature might have intended to do, if they in fact did not do it, it's up to them to fix it, that we don't fix their ineffectual changes. And so I'm not certain that your argument as to what's right is too compelling right here.
But it seems to me that there's also the argument that the legislature wouldn't change wording if it didn't have a reason to do it. And it seems to me to be logically that with their with the trend, as Justice Meyer indicated, that the last thing that they would intend to do is allow people off the hook because they simply refused a breath test when they have really no punishment for that if they don't have a driver's license, et cetera.
Let me tell you my hang-up with that argument, and it's really the one place where I'm stuck, is generally speaking, the folks across the street are never shy about criticizing court decisions. And so something this significant where the court over the years has said no warrant can go forward. You would think that in the legislative testimony, in the committee minutes, you'd have somebody showing up saying, we got to fix this series of case law. I mean, it happens all the time. So we've got the statute, we got problems, we can't read it. So we go to the legislative committee minutes, and the only thing that we've found, is some testimony from the Sheriff's Association that says we need to make a fix because we're having some problems with medical personnel and liability. Do you have anything else besides that tells us that the intent of these changes in 2008 were to correct a line of appellate court cases that said no warrant?
No, I don't.
Okay.
I would like to just add through one thing in, and just because a search warrant is issued and the test is taken does not mean that that test will be incriminating. It actually can show that the person is not DUI. If there's any further questions?
Any more questions of council? Thank you.
Okay, thank you.
You reserve 5 minutes for rebuttal.
Thank you, Ron.
Counsel, let me take my question and pop it to you. Do you have anything else from the legislative history that shows us, besides Ed Klump's testimony in the minutes, where we are with this thing?
No, Your Honor, and that's why I started my argument today by saying let's not lose sight of the original intent and how it's been interpreted for the last 55 years. If the legislature, just as you said, had really wanted to change that, they could have easily eliminated all references to warrants and put a single line in that says nothing in this act shall prohibit a law enforcement officer from obtaining a search warrant if an individual refuses under this section.
But see, I don't agree with that argument. And the reason I don't is because I can see where the legislature would want to strong arm people. I mean, this gets back to your due process argument from last spring, actually, where they would want to strong arm the gaining of consent to take these tests so that you wouldn't have to go to the trouble of pulling a magistrate out of bed and getting a search warrant. So, I mean, so this statute makes sense to me all the way through here until I mean, it's not clear, but so I want to go to the legislative history because it's hard to read, and there's nothing here to tell us anything other than Ed Klump's testimony.
3 responses to that. Number 1, as you said earlier, this would be a complete sea change in how this has been interpreted for many years, and this wasn't a very clear way to do that if that's what they did. I argued State versus Jones before this court many years ago, which had to do with the constitutionality of the PBT. It took them less than 6 months to completely change that statute to make it clear that that's not how they wanted it interpreted. So if they really wanted to do that, they could have. Number 2 is if it is for coercive effect, they would have put in the implied consent notices, what you read by the officer. If you do not consent, an officer may obtain a search warrant. They would have put that in there. If they really wanted to coerce them, that's what all those implied consent notices are. If you don't submit, you're going to lose your license for a year. You're going to have an interlock in your car. It may be used against you at trial. You may be committing a crime of refusal. Those are all in there to be coercive. Well, okay, if they're changing this so they can also get a warrant to be coercive, they certainly would have put that in those notices. They didn't. That shows it's not an intent to coerce. It's just being misinterpreted. And then why leave in, then the last thing is, then why leave in the statutory language regarding when you can get a search warrant if it's serious injury or death, if you can get a search warrant in all circumstances now? That makes absolutely no sense.
Other than Section T, that says nothing above is supposed to interfere with the admissibility of evidence obtained pursuant to a search warrant.
That's true, but there's been language such as that in the Kansas implied consent law forever. It was always this act is to be interpreted remedially, and nothing shall exclude the admissibility of evidence, violation of any portion of this act. They've always put stuff in that, and always put language in there to that same effect as a kind of a boilerplate to kind of cover their own rears. If they wanted to change this, well, they're going to need to change it anyway because the Kansas implied consent law is coercive, and they now need voluntary consent, in my opinion, before you can take a test. But besides that, if they really wanted to make this big of a sea change, then they need to do it clearly, because otherwise the court, especially with the language that's still already in there, and the fact that it's been interpreted the same way for 55 years, is not enough to show the legislature really wanted to. As you know, there's nothing even in the committee notes that would say that this is what their intention was.
Isn't there another plausible at least, an interpretation of legislative intent from the actual language of the statute? And where I'm going with that is, we can certainly see, and you would probably agree, that the purpose of the implied consent statutes are to make it easy for the state and hard for your clients, right? And we can see actually a progressive march in that direction with the criminalization now of a refusal. So isn't consistent with that intent, wouldn't it be reasonable to say that everywhere in the implied consent law that talks about getting a search warrant, what the legislature's intent was, whether or not they can constitutionally do this is a different matter, but their intent was actually to lower the warrant requirement, to create this sort of per se probable cause. Because in the text of the statute, every time it talks about getting a search warrant, it's textually tied to a per se finding of probable cause. In other words, whenever this factual situation exists, the statute dictates to the magistrate, essentially, there is probable cause. Isn't that a plausible understanding of the intent of those provisions?
You give the legislature more credit than I do. I don't think so. I think their references to probable cause and reasonable grounds are all based upon the fact that the legislature still is not under full understanding of, number one, the Constitution and how it works in a statutory framework like this. Number two, why they had the authority to coerce people in the first place was California versus Smurber. And number three, that if you're meddling with people's constitutional and statutory rights and you really want to change it, it can't be done with a piecemeal tag-on basis. We need, in the judicial area and the constitutional area, something much more clear-cut than, well, we think you guys are just trying to get harder on DUIs, but we're not sure.
Well, I think we can probably all agree with your last statement that this isn't as clear-cut as it maybe could be.
Are there any other questions?
If there are two plausible interpretations, do we have any rules that would apply?
In the criminal defense arena, luckily for my clients, statutory interpretation is to be made in favor of the defendant and their statutory and constitutional rights. So yes, Your Honor.
Would that be the rule of lenity?
That, yes, Your Honor.
We also have a rule that we apply when something is attacked constitutionally, the constitutional avoidance rule. How does that rule apply here? And where does that application of that rule leave us with your argument?
Well, to be frank, from my client's perspective, since my case is a criminal case, it actually benefits my client under my estimation, due to the fact that we're going to start off with trying to give the criminal defendant as many rights as possible, make all statutory interpretations in their favor, and I'm not asking you to declare anything unconstitutional or change anything in this case. I'm asking you to uphold the same precedent that's been followed for 55 years.
I think you would probably agree that the probable cause provisions in here may be too low.
I'm sure if I have a case that comes up where they statutorily create probable cause, you will see me in front of you arguing that that is unconstitutional. It's just not an issue before the court today.
Right. But is the extension of that theoretically, at least, that any of these warrant restrictions are gone because they have imposed a too low of a constitutional level?
No, because it wouldn't cut both ways. I mean, if the warrant restrictions are so low that the statutory scheme itself is unconstitutional, then that wouldn't eliminate my client's right to refuse. Does that make sense? I mean, I understand what you're saying, and I think you're probably right. I think there is a possibility that, regretfully, you're also right, that the legislature is trying to statutorily create what probable cause is, which they cannot do. They just, plain and simple, cannot statutorily create probable cause. It doesn't exist. And if that's what they're really trying to do, then yes, we will be back here arguing again hopefully trying to indicate to the legislature that that is an unconstitutional violation of my client's rights also.
But do you understand that when you criticize the legislature's understanding of the constitutional issues relating to DUI arrests and searches and all that, that it cuts against your argument about common sense would tell us if they wanted to change a rule that had been in place for 55 years, they would have told us differently. See, I just take those criticisms and I go, well, okay, I can't even apply common sense to this statute.
I understand that, and that's why even without the committee notes, there's no way to really determine what they really mean or what their intent is. And so instead of guessing, the easy way to do it is it's been interpreted this way for 55 years. If they really wanted to change it, there's a much clearer way to do it. But as of right now, it's unknown what their intent is. And if it's unknown what their intent is, then it cannot be said that they're clearly intended to change 55 years of precedent.
But it would seem to me that if what we're talking about is a statutory barrier to doing something that would otherwise be constitutional, go see if a judge will let you do this search, needs to be explicit. That if what we're doing is changing the path that a law enforcement officer has, it just ought to be explicit that no warrant may.
But it's been explicit that way very clearly and interpreted that way for so long.
And then
the
they
language
changed
is still there.
in 2008, and so now we've got the statute from 2008.
They eliminated some language, left all the rest of the language in regarding the warrant, and didn't say anything in there about saying law enforcement officer can obtain a warrant even if an individual refuses. That's 7 words that they could have easily been put in there. And if it was just to coerce them, the way you're saying, like I said earlier, they would have put it in the implied consent notices to coerce them. Not leave it up to every individual officer to determine whether or not they're going to tell them they might get a warrant or not. That doesn't make any sense at all.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.